everyone for joining us for today's webinar exploring restrictive covenants in a post-COVID era. My name is Rebecca Hanovice. I am an Associate General Counsel at Callaway Golf, and I'm on the board of the ACC San Diego chapter. I want to welcome everyone and also my fellow board members, Tamara Swenson, Hannah Cole, and Swen Zabka, who are joining us today as well. I also want to extend my sincerest thanks to Jackson Lewis, our sponsor, for their ongoing support of our chapter and for providing us with 3 excellent speakers for today's presentation. First, Adrienne Conrad is a principal at the law firm. She's an experienced trial lawyer, having practiced for over 20 years, and her expertise covers the entire spectrum of employment, non-competition, and trade secret litigation. She routinely counsels clients on a variety of employment practices, including contracts, handbooks, and policies, and also helps employers avoid litigation by conducting training, HR operational audits, and workplace harassment investigations. Moving on, Laura Soprano-Deck is an associate with the firm. She was a former deputy county counsel for the Office of County Counsel in Riverside and has a passion for labor and employment law. Her practice focuses on all aspects of employment litigation and counseling. And last but not least, Reina Sharma is an associate at the firm and started her career as a deputy public defender. She's spent hundreds of hours providing pro bono assistance to the California Innocence Project and the Orange County Legal Aid Society, and her practice focuses on employment law. So thank you again for joining us, and I will hand it over to our speakers.
Well, thank you, Audrey. We appreciate it, and we are very excited about being here with all of you this afternoon, albeit virtually, to talk about restrictive covenants, which, as Audrey mentioned, is one of my areas of expertise. So it's one of my favorite subjects. And I think it's also a very timely subject right now, particularly since COVID, with the labor market the way it is, employees really kind of having the upper hand and moving around quite a bit, that it's so important for employers to start thinking about how to protect their proprietary information that may be walking out the door with those employees as they are exiting. I think many times employers kind of put this subject on the back burner until they end up calling me when there's a mass exodus of employees and they're trying to figure out, what is going with these employees that could potentially harm our business. So if we can get the next slide. Okay, well, the disclaimer here that we, of course, have prepared these materials, and the information is all coming from Jackson Lewis. That certainly, as attendees, you should all consult with your counsel before taking any actions that would affect your legal rights, and consider all of these materials and discussions to be informational and not specific legal advice. Next slide. All right, so our agenda for today is, of course, to give you kind of a baseline overview of the applicable law with regard to restrictive covenants, both from a federal perspective and also from the perspective of California law, and to go over some recent California case law. Our third section is going to be on trade secret audits. I practiced before for 7 years in our Jacksonville, Florida office before transferring 4 years ago here to our San Diego office. And in Florida, as many of you may know, you can do everything: non-competes, straight non-solicitation provisions without any kind of restrictions on what the employer can protect. And so many times when it comes to trade secrets, people in California, the employers in California, aren't focusing on that because they can just go straight to the non-compete provision and say that you violated it. So when I moved here, I thought, oh, well, since trade secrets, as you will learn through our presentation, is so protected in California, that employers are going to have a great handle on what their trade secrets are. And I quickly found out that was not the case, as employers would come to me and say, we want to go after this employee. We think that they've stolen our information. And I'd say, okay, well, what are those trade secrets that you're protecting? And they still didn't really have a handle on it. So it's very important for employers to focus on this before it becomes an issue that you're then trying to protect. So we're going to go over what you should be thinking about with regard to trade secrets. We're also going to talk about how you can implement protective mechanisms to safeguard your proprietary information, how to manage employees in California when it comes to onboarding and departure to protect trade secret information and confidential information. And then we'll also go over some of the remedies for breaches of those contractual obligations that you can have in California, as well as any violations of common law. And then, of course, hopefully we will have time for questions. If we don't, because we do want to be respectful of all of your time, we certainly will take those questions offline as well, but we'll try to reserve some if we can. All right, next slide. And I will turn it over to Lara.
Thank you. So I'll just dive in with our first topic, an overview of restrictive covenants. But I wanted to start with just a general question. What is unfair competition? And when we think about unfair competition, we should think about gaining a competitive advantage by using wrong business practice, such as misusing or disclosing a company confidential information, soliciting customers, soliciting employees, or when individuals work for a competitor in a capacity where confidential information and goodwill may be misused. So what can employers do to protect their confidential information against unfair competition? Well, restrictive covenants are a good tool that employers should use to prevent employees from disclosing their confidential information, soliciting customers and employees, or misappropriating trade secrets. So which law applies when we think about restrictive covenants? Well, there is no federal law directly covering restrictive covenants. So this means that legislation and regulation is left to the states. So we can think about this nice patchwork, especially when companies have employees working remotely all over the United States. There has been a push now from the White House too. The Biden administration issued an executive order last year encouraging the Federal Trade Commission to, and I quote, curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So we should pay close attention to how the FTC will respond to this executive order, as that may impact the way we draft non-compete agreements and whether they are or remain enforceable. Next slide. So yeah, we are experiencing a changing landscape for restrictive covenants, and this has been going on for about 4 to 6 years. Even during the Obama administration, the White House had issued a call to action to state governments, asking them to consider limiting non-competes. And the Biden administration, as I just mentioned, has been publishing a plan to eliminate non-compete agreements, except obviously those necessary to protect trade secrets. And so since 2016, 16 states and the District of Columbia have passed legislation regarding restrictive covenants, although most reforms are not targeting confidentiality restrictions or non-solicitation restrictions. Slide 7. All right, so what about California law? California always seems to be the exception to almost everything. And in fact, California has a strong policy against restrictive covenants. And this public policy is codified in California Business and Profession Code, section 16600, which states that any covenant that restricts a person from engaging in a lawful profession, trade, or business is generally void and unenforceable. So there you have it. And this statute basically expresses a legislative policy in favor of open competition and employee mobility. So generally speaking, in California, non-compete agreements are void and unenforceable unless they qualify for a statutory exception. So what are these statutory exceptions to the general rule prohibiting restrictive covenants? Well, exceptions relate to agreements that are entered into in connection with three specific situations. The first one is the sale of a business entity or the goodwill of a business. The second one is the dissolution of a partnership. And the third one is the dissolution of or termination of an interest in a limited liability company. So the first exception, sale of business, basically allows a seller to agree with the buyer to refrain from carrying on a similar business within a specific area in which the business so sold has been carried on if the buyer or any person deriving title to the goodwill carries on a similar business in the area. The second exception allows a partner, in anticipation of the dissolution of the partnership, to agree with the buyer that he or she will not carry on a similar business within a specific geographic area where the partnership business has been transacted, so long as the other members of the partnership carries on a similar business. And the third exception allows a member, in anticipation of the dissolution or the termination of his or her interest in the limited liability company, to agree with the buyer that she or he will not carry on a similar business within a specific geographic area, so long as any member of the limited liability company carries on a similar business. So these are the three statutory exceptions. Now, if we think about the protectable interest that justify enforceable non-compete agreements within these three statutory exceptions, well, courts have explained that one of the primary goals, a list of section 16601, which regards the sale of business, is to protect the buyer's interest in preserving the goodwill of the acquired corporation. So the thrust of this section is to permit the purchaser of a business to protect himself or itself against competition from the very seller, which competition would have the effect of basically reducing the value of the goodwill and the property right that has just been acquired. Now, even within these three statutory exceptions, however, there are some time restrictions and geographic restrictions. For example, all three exceptions fix the temporal limit of the non-compete for so long as the buyer carries on a similar business. And the California Supreme Court has held that such a duration, which seems pretty broad, but basically so long as the buyer carries on a like business in that specific geographic area, this limitation is enforceable. And for geographic restrictions, non-competes entered into connection with the sale of business, the geographic limitation must be within a specified geographic area in which the business so sold has been carried on. So basically section 16601, the one that relates to the sale of business, allows a seller to agree not to compete with the buyer in the geographic location where the seller has carried on the business. So basically the geographic limitation can cover the entire United States if the business operates in all 50 states. For the other non-competes entered into in connection with the other two exceptions, the dissolution of the partnership or the dissolution of a limited liability company, the geographic scope is very similar within a specified geographic area where the partnership or the limited liability company business has been transacted. Now, are there other exceptions that we can think of, or are we limited to statutory exceptions? Well, courts over the years have held that customers and employees' non-solicitation agreements may be enforceable to the extent they protect an employer's trade secret. California courts have also permitted covenants like confidentiality agreements to prevent the misappropriation of trade secrets and unfair competition. What about during employment? Well, California courts have held that an employer may restrict an employee from competing with the employer during employment. And it is important also to think about when employers ask employees to sign employment agreements that include unenforceable restrictive covenants. What happened then? Well, if an employer's termination of an employee, if an employer terminates an employee that refuses to sign such an agreement that includes an unenforceable restrictive covenant, there we may have a wrongful termination in violation of public policy. So slide 13, a closer look to customer non-solicitation covenants. They are generally considered non-compete agreements or non-compete covenants, and so generally are void and unenforceable unless they are also subject to the 3 statutory exceptions. However, some courts have held that customer non-solicitation agreements may be enforceable to the extent they protect a company's trade secrets. However, even within this, let's say, exception crafted by the courts, employers need to be careful not to draft these customer non-solicitation covenants too broadly. For example, non-solicitation agreements that prohibit a former employee from soliciting the potential customers of the former employer or customers who no longer work for the former employer. Those are way too broad and may be considered unenforceable. If we think about, again, the protected interest when we think about customer non-solicitation agreements, this is very similar to non-compete agreements in general. So what we're trying to achieve when we think about customer non-solicitation covenants within the 3 statutory exception is the goodwill. So the buyer just buys the goodwill of a corporation, and the seller basically can now turn around and start soliciting customers. Otherwise, there is a huge decrease of the value of the business that was just purchased. So goodwill, we just talked about it, and that applies to non-compete in general, but also to customer non-solicitation agreements. And for trade secrets, some California courts, like I mentioned, have found customer non-solicitation agreements enforceable to the extent they protect employer trade secrets, because although they are anti-solicitation covenants and they may be viewed as unlawful business restraints, they may be enforceable where enforcement is necessary to protect the confidential information in the trade secret. There have been cases, in fact, that they upheld the customer non-solicitation agreement where the employee agreed not to use the employer's confidential list to solicit customers. Now, an important note I wanted to add, and I'll discuss this later on when I talk about 2 important cases that came down this year, is what does it mean solicitation? And obviously, every time there will be also a fact-intensive analysis for the court. But generally, announcing one's change of employment to a former employer's customer is not solicitation, even if those customers are protected trade secrets. So merely informing customers of one's former employer of a change of employment without more is not solicitation. And this is relevant if we think about social media nowadays, right, where we basically post everything and anything there. However, using data that is trade secret to actively solicit clients of a former employer, that is an solicitation and misappropriation of trade secret. And this will be relevant in one of the cases that I'll talk about in a minute that came down this year. So that was about customer non-solicitation covenants. What about employee non-solicitation covenant? And this is slide 15. For employee non-solicitation covenants, the California Supreme Court has yet to rule on the legality of such covenants, and there is conflicting authority among lower courts. And we have seen cases such as the Laurel Corp v. Moy, where the court upheld an employee non-solicitation agreement that prohibited an employee from disrupting, impairing, damaging, interfering with his former employer by soliciting the former employer's employees. Versus AMN Healthcare, where the court, the appellate court, affirmed the trial court determination that the non-solicitation covenant that was barring former employees from soliciting the employees of their former employer was held unenforceable. But there at issue, and I think this is something that I need to point out because it will be an important distinction based on facts. In AMN Healthcare, the employee's business, the employee's profession was actually recruiting. So the takeaway is that it may be prudent for employers in general to refrain from utilizing employee non-solicitation covenants, particularly in the context where the job functions include recruitment, unless the non-solicitation provision is worded in a way to prevent former employees to use trade secret information to identify and then solicit employees of former employers. Now, always in the context of employee non-solicitation covenants, what are the protectable interests? Well, in the Laura Corp case, the purpose of the restriction, and that's why the employee non-solicitation clause was upheld, was to maintain a stable workforce that would allow the employer to remain in business. Now, slide 17. There have been a number of cases that came down this year, and we just wanted to introduce two that we thought were kind of relevant to today's presentation to restrictive covenants. One is the Blue Mountain Enterprises, LLC v. Owen. And this was a decision about customer non-solicitation in the context of the sale of business. And in Blue Mountain Enterprises, the appellate court affirmed the trial court preliminary and permanent injunctive relief that prohibited the defendant, who was a former employee but also former owner, so the seller in this case, from soliciting the employees of the business that he had just sold. And in that particular case, the customer non-solicitation covenant was upheld because the defendant seller was not just announcing a change of business, but was actually actively writing letters to the customers of his former employer and former business. So that's why earlier I mentioned we need to be careful when we define maybe what it means to solicit customers, even in our agreements, most of the time confidentiality agreements. And the other relevant case is LG CY Power LLC v. Superior Court. This was an interesting case. It was within the restrictive covenant context, although this opinion talks a lot about civil procedure. I will not bore you with. But in this case, the Court of Appeal was asked to address the interplay between Section 925 of the Labor Code, of the California Labor Code, and California Compulsory Cross-Complaint Statute. Just a little introduction to Section 925 of the California Labor Code. And this is interesting, especially like I mentioned before, when we have California employers that have employees in California, but also in other states, or employers in other states that have employees in California. So Section 925 of the California Labor Code provides that employers cannot force an employee who resides and works primarily in California to agree as a condition of employment to, inter alia, litigate a claim arising in California in a forum outside of California. So in this particular case, and I'll just give you an overview and a summary of the facts, the former employer had already filed suit in Utah against former employees who had left employment and had gone to work for a competitor. Most of those former employees' defendants had filed cross complaints in Utah, except for one. And this individual defendant filed a new lawsuit against the same employer based on the same facts, but in a Fresno Superior Court here in California. So you can see the interplay between Section 925, which would prohibit an employer from forcing the employee not litigating a case that arises in California but outside California, with the compulsory cross complaint statute. Well, the holdings here was that Section 925 does provide an exception to California compulsory cross complaint statute, such that an employee who comes within the purview of Section 925 may file a complaint in California alleging claims that are related to the causes of action that their employer has already filed against them in a pending action in a sister state. So this was a little bit convoluted with a civil procedure. I had to go back to my first year of civil procedure class, but this is just to keep in mind. This is a very good case to keep in mind, especially if we have employers with employees in various states, especially employees who reside and works in California.
Yeah, if I could just also quickly say that when it comes to Section 925, that really kind of ended what employers were able to do before, which was to try to enforce non-compete agreements that were valid in other states against California employees. And for a while, we were able to do that, but 925 put a stop to it.
All right, so if restricted covenants are prohibited in California, how do you protect your business against unfair competition? Well, we suggest that you're going to do that by protecting your trade secrets and conducting a trade secrets audit. We're going to break down this section by discussing both the Federal and State Trade Secrets Act, discussing the importance of protecting trade secrets, and how to conduct a trade secrets audit. When we discuss conducting an audit, we'll look at three major prongs of the audit itself: identifying and defining your trade secrets, which is very important. It's the step that the business is going to be taking on their own because they're the ones with the knowledge of what their trade secrets are. How to implement protective mechanisms, and managing your employees, which Laura will cover in depth. So, well, what exactly is a trade secret? The Federal Defend Trade Secrets Act defines the term trade secret broadly. It includes all forms and types of financial, business, scientific, technical, economical, and engineering information, so long as the owner of the information has, one, taken reasonable measures to keep such information secret, and two, the information derives independent economic value from not being generally known to or readily ascertainable through proper means by another person. So in digestible terms, do you have information? Did you take steps to protect that information? And is there a value to this information that is generally unknown by others? A key example you can think of is Coca-Cola's secret recipe. They take steps to protect that information from the public and other companies. And the formula provides them with economic value of customers choosing to go with their product over others. I mean, me personally, I do prefer some Coca-Cola because of their secret recipe, because customers like their taste that the formula provides. So of course, there are other examples such as computer software, cost pricing information, plans, designs, patterns for specialized equipment, any kind of information that your business deems that it wants to keep a secret that brings that value, that special value to your company. So the Defend Trade Secrets Act provides a cause of action for the misappropriation of trade secrets. Misappropriate means that another person acquired the information by improper means, or by the disclosure or use of that information without express or implied consent. Improper means can include theft, bribery, misrepresentation, breach, or inducement of a breach of duty to maintain a secret or espionage. It does not include reverse engineering, independent derivation, or other lawful means of acquisition. The Defend Trade Secrets Act also provides immunity to whistleblowers who misappropriate trade secrets with the intention of reporting, investigating, or seeking relief for violations of the law. So here's a list of some remedies that you would be able to bring an action under the federal Defend Trade Secrets Act. This includes injunctions, actual damages, unjust enrichment, royalties, and in exceptional circumstances, civil seizure. And Adrian will go over remedies more in depth at a later point in time. So the Uniform Trade Secrets Act has been adopted by 48 states, including Washington, D.C., Puerto Rico, and the U.S. Virgin Islands. However, it has not been adopted by New York and North Carolina. In 1984, California implemented the California Uniform Trade Secrets Act, which similarly protects companies against the misappropriation of trade secrets. The three major differences between the federal Defend Trade Secret Act and the California Uniform Trade Secret Act is that one, the California Uniform Trade Secret Act does not require that a trade secret not be readily ascertainable by the public. However, it still must not be generally known to the public. So that factor of like, if somebody goes searching for it, could they find it? That's not as much of a factor as is it just generally not known? Two, California Uniform Trade Secrets Act does not allow for civil seizure as a remedy. And three, the California Uniform Trade Secret Act does not provide whistleblower immunity. It's important to protect your trade secrets because if you don't, neither will the courts. In New York, the court in Art and Cook Inc. versus Haber would not enjoin a former employee for misappropriation of product designs and marketing strategies because the employer did not do enough to protect them, even though designs and strategies are normally qualified as trade secrets. The employer did use passwords and attempted to protect outside hacking, but it did not require employees to sign a non-compete or non-disclosure agreement as a condition to access this information. So bottom line is you need to take steps to protect your trade secrets because it's very difficult to recover that value through successful legal action. The bar is higher. So let's move on to how to conduct a trade secrets audit to protect your company against unfair competition. Conducting your audit will basically be an internal investigation or assessment of the information you want to protect. In this process, you'll identify a point person to assist with the audit process, arrange interviews with the heads of departments, and verify compliance with the trade secret protection measures. So in order to protect your trade secrets, you're going to need to identify and define with particularity what those trade secrets are. And to do this, you might want to first consult with the relevant departments to assess and access the importance of protecting certain pieces of information. An important consideration when identifying which information you want to protect is to ask yourself, would this information give my company's competitor an advantage if they had access to it? Make sure you consult with counsel and human resources to verify your ownership over this information, and review any information that has been published by your company to ensure it's not publicly available. This means you need to comb through your company website, marketing materials to confirm that the information you seek to protect is not accessible to the public. The most important step of your audit will be to implement protective mechanisms. So let's go over how to do this specifically in California. Businesses can look beyond the statutory law to protect its interests and enter into contractual agreements with employees to restrict certain conduct. When onboarding new employees, it's important to include confidentiality and non-disclosure agreements before allowing employees to access trade secrets. And there are a few standard protective clauses, not all apply to California. So there's confidentiality provisions defining what confidential information is, return of property provisions relating to the time of separation. So the employee knows they need to return certain property that contains information of the property of the company as well. Intellectual property and works of authorship provisions. And then this is generally prohibited in California, the prohibition against solicitation of employees, and also prohibited in California is the prohibition against solicitation of and doing business with other customers, and also generally prohibited in California, the prohibition against competition. In California, the non-solicitation of employees may be okay as long as it doesn't restrain their living, and Laura already touched on this. And by trying a non-solicitation covenant with the use of trade secrets, so tying it together, that's going to be more likely to be upheld in a California court. So that's why it's also important that you know what your trade secrets are if you're tying this to certain provisions that usually a court would strike down without that trade secret element. Jurisdictions vary in this area of law, but generally we want to be cautious. I mentioned briefly that we need to carefully scrutinize restrictive covenants and non-solicitation clauses because they limit employee mobility. It must be justified by a legitimate business interest, which is the protection of confidential information and or customer goodwill. In addition to the state law restrictions, there may be industry-specific limitations. For example, the FINRA prohibits limitations on a customer's ability to do business with a financial advisor of their choosing. There are also ethical considerations that may vary from jurisdiction to jurisdiction. For example, in Minnesota, there's a professional rule of conduct 5.6 that generally prohibits agreements restricting the right of lawyers to practice as affecting the freedom of clients to choose a lawyer. So you want to be careful of the laws and the ethical considerations. Depending on which jurisdiction you're in, that's going to change. So here are some questions to consider when implementing protections for your trade secrets. Do you label your confidential materials? Do you segregate confidential materials? We talked about earlier how there was a case in New York where an employer took certain steps, but they didn't go far enough to protect their information. And so we want to make sure that we're taking each step to identify and protect these secrets. And by labeling it, identifying it, labeling it, segregating it, you're already making those first steps. Do you limit access to confidential materials with respect to employees? Which employees have access to this trade secret? With respect to third parties, vendors, contractors, visitors, how do you log access to confidential materials? Do you maintain electronic records of whom, what, when, who has access, what they have access to, when do they have access to this? Do you restrict the removal of confidential materials from company property? And this goes back to the provisions that can be in the employee contract about returning company property as well. Do you condition access to confidential materials on written executed agreements, including all those provisions we had talked about earlier? And do you regulate off-site access to electronic confidential materials? So this means combing through your website. Sometimes information may be on there that discusses or talks about this trade secret. Want to make sure that you're regulating that, you're not giving out the actual trade secret itself on these websites. Have you implemented anti-hacking initiative, firewalls, antivirus, anti-malware software, encryptions? Have you developed a protocol for responding to inadvertent disclosures of confidential materials? Have you implemented a data loss protection system? Do you protect against data loss through mobile devices? So if you have employees who have access to certain materials on their phone, what steps are being taken to limit the employees who have access to trade secrets through their mobile devices? How are we monitoring the data that is going to mobile devices? Do you employ a bring your own device policy? And if so, have you considered the associated risks of leaked information? And do you have written policies and procedures regarding confidentiality and non-disclosures? So these are all the questions, not all, but the questions you want to be asking yourself. Am I taking those steps? Because as I mentioned before, your company is going to care the most about your trade secret. The courts are going to protect other interests. So you want to make sure that from the very beginning that you're considering all of these questions when you're setting up how to protect your trade secret information. And part of that, which Laura is now going to dive into, is managing your employees as well.
Sorry, I was on mute. All right, so section 5 of our presentation deals very briefly with managing employees. What does that mean? Well, we have situations where employees leave, but also situations where we onboard new employees. So Raina already covered some protective mechanisms such as confidentiality agreements and enforceable restrictive covenants, where you can tie employee and customer non-solicitation clauses to the non-disclosure of the company's trade secret. And these are actions, like Karina mentioned, that you should do obviously when the employment relationship starts, but those are things that you will go back to when the employee leaves. So other considerations are, for example, protect your computer information. This means, like Reina mentioned, identifying trade secret, proprietary information, identify the individual who have access to that information, implement password protected system, firewall system, backup systems. And when the employee departs the company, make sure that you terminate computer access and check that the department employee does not have hardware, files, accounts. Implement checklists and ways to determine whether employees right before leaving have downloaded or emailed themselves company files or documents. And sometimes these may require the engagement of services of an outside, unless you have an inside digital forensic expert. Review confidential agreements, but also if you have executive and employment agreements with executive, just make sure that you update them annually. So train also your HR department to understand which employment agreements to use, which confidentiality agreements to use, and use exit interviews if you can. I know it's not always possible, especially like I mentioned before, in today's world where a lot of employees work remotely. But if there are any exit interviews, just remind your employees about the agreement that they signed when they started working for you. And collect company's property, obviously in possession of the department employee, and also kind of trying to understand which position did the employee cover while employed by you, to kind of trying to understand, was he really in possession probably of confidential information as performing his job, or was he in a position where he also did not even have access to that information? And then the last step is investigate. If you have any suspicion of theft of proprietary information, then investigation should be done before you accuse anyone, right, of stealing your proprietary information. And even here, unless you have an inside IT department, you may want to engage the services of an outside forensic expert. And then the last slide regarding this topic is managing the onboarding of employees, because it may be that employees that come and work for you had confidentiality agreements with their previous employers. So what should we do? These are just general suggestions, but it is very important that also during the recruiting process, before an offer is made, even if you engage, for example, outside recruiters, it should be made clear to them as well that as they start interviewing and talking to candidates, it's important to make the candidates understand that the company takes confidential information and the use of confidential information really seriously. So even ask these new hires or these candidates, did you have confidentiality agreements, or did you have any type of agreements with your previous employer? And make sure that they cannot take anything with them, you know, as there is this change of employment. During the offer process, maybe you should consider including language in the offer itself where the employee states, and obviously then acknowledges and signs, that he or she has now brought any confidential or trade secret information from the previous employer. If you offer a confidentiality agreement, maybe the good practice would be to mention the confidentiality agreement in the offer letter and then attach it as an exhibit. And then just generally implement step-by-step process or a step-by-step checklist where you go over with a new hire. Okay, this is what the company policy is. This is why we want you to be aware about our policy about confidential information. Ensure that the new hires understand what trade secrets and confidential information is for your company. And sometimes if the new hire is restricted by previous agreements, you may even want to consider offer the prior employer a certification that the employee is not using or transferring any prior confidential information. And this was it for the management of employees section.
Okay, so with everything that Laura and Reina went over, those are all things that we really encourage employers to make sure they have in place so that it makes it easier for you to try to enforce any of the restrictive covenants that you are allowed to have in California. Can we go to the next slide? And I apologize, I think there's some noise outside my door, but hopefully you can hear me. When it comes to the remedies for breach, you know, whether it's a non-compete that you're allowed to have under the statutory exceptions, or, you know, very carefully crafted non-solicitation provisions with regard to customers and employees, the important thing is figuring out, okay, can I even make a claim against the employee or against the employee's new employer? And so many employers will come to me and they'll say, okay, we know that this individual has breached their contractual agreements or they violated, California common law. And I'll say, okay, so you've looked at their devices, you've looked at their email accounts, you've found the breadcrumbs that shows that they violated. Oh no, we didn't pull any of that. Like, okay, we need to have something to hang our hat on in order to get to the courts to get some sort of remedy for you. So oftentimes they will go back, they'll pull that information, we'll do a forensic review of the employee's electronic devices. We look at the email accounts, and sometimes there's no breadcrumbs, there's no smoking gun that shows that that individual actually did anything. And that can be very frustrating for employers because a lot of times they feel like we know that something was done here and we want to go after this individual. But there are times that, people do not cover their tracks very well. And so you do the forensic review of their devices and you see, oh, there was some sort of external device that was attached to the computer and we can see that information was downloaded. Or we look at their email accounts and we see where they were sending information either to their personal account or to a third party, where we can show that there was confidential information being taken. Or sometimes there's even video of the individual walking out with arms filled with reams of paper that was company property that they shouldn't be taking. And in those situations where we can kind of say, yes, there's a breadcrumb trail here of what this individual was doing, then you can go to the courts and, if you're seeking immediate relief, injunctive relief, either a temporary protective order that then turns into a preliminary protective order to eventually get a permanent injunction. That is, the immediate relief where you're trying to get the status quo in place, not have anything change, have that individual stop using your information. But those can be very expensive, right? You're going in, it's an immediate thing. You have tens of thousands of dollars that you're going to have to spend in what's virtually a mini trial without having a substantive discovery at your fingertips. So that can be very fast-paced and very difficult. Then you have, let's say you go straight to court. You're not looking for temporary injunctive relief, but you filed a complaint for breach of contract, where you're trying to get compensatory damages. Or maybe there's, the violation of California common law, where you're seeking monetary damages. And then there's also injunctive relief and restitution that you can get under the California unfair competition law. Next slide, please. So now let's say that you have a confidentiality agreement. Let's say that you're one of those employers that, whoops, I had a restrictive covenant agreement that I had all of my employees in another state sign, and we actually accidentally had our California employees sign them too, and it has unlawful non-competition provisions, unlawful non-solicitation provisions, but there's still a valid confidentiality provision, because even if those other provisions are unlawful, you can still enforce the confidentiality provision. So in that situation, there's a very important distinction that employers should be aware of. Let's say the non-solicitation provision was well crafted. It was tied to trade secrets, but a court could find, and I've had this happen in a case, the court looks at it and says, no, I can't find that that employee used trade secret information to solicit. But there was confidential information that didn't qualify as trade secret information, but it was confidential that that person used in violation of their confidentiality provision. And so in that situation, that confidentiality provision saved that employer and allowed them to still get injunctive relief and to still get compensatory damages for breach of that confidentiality provision. So it's very important to remember that there's always other options that you can choose if there's some violation that you're unable to prove. You can always try to fall back on the confidentiality provision. Now, the note here is that sometimes employers do have a liquidated damages provision. Courts typically do not like those. They don't like to enforce them. You can have them in there to say, look, I don't have to prove damages, because that's often the hurdle that employers have in addition to proving that someone violated an agreement. But you can have it in there as a way to kind of deter the individual from doing anything else. Next slide, please. And I know we're running out of time, so I'm not going to go through each one of these bullet points. You'll have the slides, but it's important to consider, whether you have that information that you need to show that there was a violation, to determine where you want to file. Are you going to be better in state court or federal court? And that's something you want to really talk through your counsel with. And then potential ramifications. Are you going to have to post a bond? That's going to cost you money in case the court finds that you shouldn't have gotten that injunction against the employee. You would have to reimburse that person for them being put out of work. And are you comfortable with it being public? And also the cost of going forward with seeking to enforce restrictive covenants. Next slide. So the key takeaways that we will leave you with is that, as Laura mentioned, the landscape is changing. And in California, it's changing towards the employer not having very many avenues to go after employees who they feel are unfairly competing against them. But there are ways that you can protect yourselves. So you can protect your legitimate business interests through confidentiality agreements and through carefully drawn non-solicitation and non-compete agreements. And, in all of these situations, you want to be sure to consult with counsel, especially even before sending out a cease and desist letter, because oftentimes if it is an unenforceable provision that you are citing to, there is the potential for that employee to have a cause of action against the company for trying to enforce an unenforceable provision. So you want to be sure that you talk it through before you take any of those actions. So next slide. I know we are right at the time here, so there's not a lot of time for questions, and I don't see any questions in the chat. I know we did get one question this morning about whether or not non-competition and non-solicitation provisions can be enforced against a company that has an independent contractor. And independent contractors, it's basically the same thing as with regards to employees. Whether or not that non-competition agreement falls within the 3 exceptions under Section 1600, and whether or not the non-solicitation provision is sufficiently tied to trade secrets and narrow so that it can be enforced. If not, then there's the argument that they can't enforce those provisions. Well, I know we are at our time. We always like to end on time for everyone. If you have any questions, we have our email addresses there. Please feel free to email us, and we'd be happy to get you those answers. So we really enjoyed our time with you today.
Thank you so much for your time and your expertise. To the attendees, you can get the slides on the ACC site, and hope to see you at future events.
Thank you.
Thanks.